The numbers are still ticking up, but I think we'll get started now. Welcome to all of you who've joined us already. My name is John Coldham and I'm hosting today's event. First of all, I'd just like to say welcome to our 8th annual event as part of London Design Festival. This is our first one where we've done it online, which has meant that more people have been able to join us. So if this is your first time at one of our events, welcome. A warm welcome back to all of you who've attended on previous occasions. I'm sorry that this time we can't offer you a drink overlooking the Thames, but I hope we'll be able to do that again when we meet next year. As the discussion usually carries on after the event and sometimes long into the evening, which of course, by the way, we start later than 11 o'clock, which of course is not possible this year, I would encourage you to provide your comments and questions as we go along in the Q&A function. I'm impressed that a couple of you have already done that, which is very, very keen indeed, so thank you. I'd encourage you to do that because that will help with the discussion. We'll try to incorporate as many of your questions and comments into the discussion as we go, and we've also allowed some dedicated time at the end to deal with questions. There may be some questions that are either too specific or not. We run out of time, and if that's the case, we'll try and get back to you directly after the event. If you have any colleagues or other contacts who would maybe have liked to have attended this webinar but haven't been able to make it, we will be sending you a link to the recording of the webinar by email afterwards, and it will also be available on our website in a couple of days' time. When this webinar is finished, we'll be sending around a feedback form. I think it will appear on your screen when the webinar finishes, but we'll also be emailing a link to it afterwards. I know every webinar you attend will say something like this, but we really do appreciate the feedback that we receive, and it does help inform our future events. So please do provide any comments, good or bad, and we have thick skins. Please do let us know if there's anything that you would like us to improve. If you're interested in finding out more about design law generally, we have a dedicated webpage at gowlingwlg.com/designs for life. This has a guide to design law and its protection, as well as podcasts and videos from our previous London Design Festival events, as well as elsewhere. I should mention that this event is deliberately not too legally focused. We are running a series of more legal webinars on different parts of brands and designs law, including a more in-depth look at the impending changes caused by Brexit in the coming weeks. And we will provide you with further information about that at the end of the webinar, but also by email. In our advertising for this event, we quoted Oscar Wilde's infamous line that imitation is the sincerest form of flattery that mediocrity can pay to greatness. Now, while this quote might perhaps make those who are ripped off feel morally superior to those who do the copying, it doesn't generally help the bottom line. But is it that straightforward? Can being copied ever be good news? Well, the default answer from most brands and designers would, of course, be no, it's a nightmare. But the issue is perhaps more complex than this, so we felt it would be interesting to examine it in more detail today. How can you turn a seemingly negative experience into a positive one? How can being copied be something that you can turn to your advantage? The purpose of this event is to look at different perspectives, to encourage you to look at the issues around intellectual property infringement from a different angle. I've already mentioned our other webinars over the next few months that will help you through the legal issues, from strategy to practicality. So we've deliberately kept off the specifics of the legal side in this event. And to do this, I am pleased to welcome a stellar panel of speakers. Now, all of them have at least some link to law, as I shall explain. But the reason we've invited each of them to join the panel today is due to their involvement in design. Martin Darbyshire is co-founder of the well-known design agency Tangerine. Martin has generously supported our event at the London Design Festival ever since we started 8 years ago, and has joined our panel each year. Martin is, and this is just a selection of his achievements, he's a trustee of the Design Council, he sits on the government's Infrastructure Exports Board, and he judges the Red Dot Awards. And his design achievements include the first fully the Sky Plus box, and many others. Martin's link to law is that he was an expert witness in a major intellectual property dispute about aircraft seats, a case that ended up at the Supreme Court. John Ayton MBE co-founded the well-known jewellery chain Links of London with his wife before selling it in 2006 and co-founding Annoushka, a top-quality jewellery brand that makes beautiful and unique designs. John has also been involved in various other brands, including Bremont watches, and has many other claims to fame besides. These include carrying the Olympic torch as part of the London 2012 relay, which was as a result of Annoushka and his support for British athletes through fundraising and ambassadorial efforts for Team 2012. And John's link to law is that he originally practiced as a lawyer in both Hong Kong and London before thinking better of it and moving into the world of design. Sam Jacob is an architect with his own studio in London. Sam is also a professor of architecture at the University of Illinois and director of night school at the Architectural Association. Sam has also written some fascinating opinion pieces for Dezeen over the years, and Sam's link to law was unknown to me until we had our first chat about participation in this event. It turns out that Sam's dad is the now retired Lord Justice Jacob, perhaps one of the best known, well, perhaps the best known intellectual property judge of the last few decades, and responsible for many of the leading cases that we follow to this day. Most of us in the IP world will never forget our hearings in front of Sam's dad. I gather that Sam has told his dad he's speaking about IP today, and I noticed that he hasn't decided to sign up. Anyway, enough of that, let's get going. First off, I thought it would be helpful to go straight into the question at hand. I don't want to be accused of not having dealt with the question that we advertised, which is, can copying ever be good news? John, why don't you go first and give us your take on this question?
Well, I think it's interesting. All the brands that I've been involved with have had an important point of difference. So whether it was All-Bar Brown, it was the fact that it had a buckle on the side of the short, reminiscent of Savile Row tailoring. For Bremont, it was the construction of a three-part case. For Links of London, it was the Sweetie bracelet with a very unique way of attaching charms, which was say core to the offer. And at Grind, it's about the pink tin. So these were always considered to be absolutely core to the brand and something that should be defended at all costs. But as we all know, defending intellectual property is not straightforward. And it often requires a sort of many-tiered approach. And a great example of when it can be good news was very early on when we started Links of London in the early 90s. We were doing mainly cufflinks, and suddenly M&S produced a train cufflink, which was an identical copy of the one that we produced months before. And by looking at the size, we were able to tell that they'd taken a cast from the original. And it was so clear by the small amount that every single dimension had been reduced that we had a very strong case of not only copying, but actually taking a mold from the product. Anyway, a few weeks later, M&S did the decent thing, paid us the princely sum of £10,000 and kept our business going. So I shall be eternally grateful to M&S for their financial support at the early stages of that business. So when it doesn't go to the core of your business, as this didn't, it can occasionally be good news. I think if we look at the slides, I'll just talk you through a current issue that we have. Because at the end of the day, when design and craft is right at the center of your brand, which is very much where we are with Annoushka, you know, the most important thing is we want to be perceived as original design, individual and creative. And this can be difficult in an industry that's been going for many thousands of years and is very limited by the functionality of jewelry. So people are constantly reinventing nuanced designs. But for us, the fact that it is an important part of our brand value that our design is innovative and not imitative. We have had difficulty over this particular collection called the Crown Collection. And if you look, you can see that it's very reminiscent of a crown. The neat thing about this is the two parts will join together to create a laced structure, and it's very neat, very comfortable, and so forth. We launched this in 2016 as an original design. We featured it in this advertising campaign, you can see. And if you move on a slide, you'll start to get the idea of the way they slot together. Annoushka was a very early pioneer of stacking rings. And then if you move on to the next one, you'll see another variation of the way it was shot. And then if you move on to the next one, you'll start to see the imitations. But not only has the product been imitated, but also the way that it's presented. So for us, this went one step too far in that it created a passing off situation rather than taking inspiration. And I guess what I want to say is that our worry was, will it affect sales? Well, that's a difficult one. Maybe people will find the design too common because they think and feel that it doesn't deserve the premium pricing, or or conversely that people are producing it in lower quality metals and so forth. So I think a lot of smaller companies have a real problem with imitation with larger companies who then splash the product over advertising pages and social media. And the consumer will often look at it and say, well, actually, were they the originator of this interesting design? And make the originator look imitative. So I think it's a lot of it is about reputation and how close it sits to the core proposition of the brand.
John, when you've had problems, please don't name any names, but when you've had problems with any other brands in either on these slides or otherwise, what have you done about it? Have you gone down the legal route? Have you had a word in an ear, or how do you approach it at Annoushka? Obviously, if you don't want to answer the question because it's how you deal with it, maybe your business, then feel free not to. But any pointers for those listening as to what you found works best?
I think it's very much, it's not one size fits all. I think that certainly within the jewelry industry, I think you have to be, it's very different if you get an interpretation by another jewelry business, which is taking an existing design language and interpreting it in terms of trends. It's very different from getting a high street retailer who might be just taking a design and replicating it in a cheaper fashion. For the latter, we would tend to instruct lawyers and go for a much stronger response. And in the past, that's resulted in billboards being taken down, catalogs being pulped, and the like. But from a jeweler point of view, I think, and looking at other jewelers, I think that can be much more subtle, and that will often start with, hang on a minute, you're getting very close here. Will you please take a look at the inspiration? And we do, we do on quite a regular basis write that sort of letter, and I think it's good for the industry. It keeps everyone in check.
Yeah. And do you find, last question before I really move on to Martin, do you find this is actually, we've had a question from somebody who wants to know basically how do small sole traders and small businesses deal with issues like this? You know, Annoushka is a reasonably sized brand, and if you threaten legal proceedings, people will probably believe you that you'll do it. You know, but you pointed out, I think, that sometimes just pointing out the infringement to the brand can sometimes be enough, if I've understood what you're saying correctly, because it may be that the left arm isn't talking to the right arm and they didn't know that their supplier had copied, and so on. So sometimes a polite-ish letter explaining the problem can have an effect. That seems to be what you're suggesting, is it?
Yeah, I think it can. I mean, I think there are other ways of publicizing. I mean, Diet Prada would be a good example in social media, where they will often feature the most outrageous forms of copying, and are brave about putting up the original and the pretender.
Yeah,
I think that's an interesting way where you can draw attention to the fact that you have been copied. But there again, you've got to you know, you'll have a lot of legal threats thrown back at you if people think you're being libelous or
yeah,
so forth.
Yeah.
But, I think you in order to take a large company on as a sole trader or as a small company, you've got to have you know, it's very, very expensive.
Yeah. I think, I mean, obviously, as you say, there are ways to deal with it that are not necessarily quite so expensive. I mean, I should put in a word for the IP pro bono scheme, which is a scheme that lots of the major intellectual property firms are participating in, including us, where you can, if you're a small trader, make a sort of bid for pro bono representation specifically to do with IP, and that's a very good scheme. And sometimes you can deal with these things through an initial skirmish that makes it go away. Anyway, we better move on. I'm conscious of time. Martin, going back to the question of can being copied ever be good news? You work for you run a design consultancy, so I imagine I know what your answer is going to be, but why don't you give us your take on this?
Thanks, John. So when we first thought about this issue, and then we had various chats before leading up to the event. For me, the categorical answer is no. And I think if you're a design consultancy that is essentially creating value for clients through design or innovation and IP, then that value is critical. And of course, IP and understanding IP is also critical for our clients. So our clients are not just looking us to create original things. They're making us sign contracts that tell them we're not going to copy anybody. They're also asking us to give them advice around IP in many ways, which generally is, this is my level of understanding, but you need to seek advice of a professional if you want to do something properly. And also, in many cases, they're making us sign contracts or asking us to sign contracts where we will indemnify them against any losses should there be an infringement of a third party's IP. Now, obviously, we work very hard to avoid that, but that's what businesses are expecting of us. So I think that the short answer to the question really is about context. It very much depends on what you're doing. I think, having reflected on it, there are some exceptional circumstances, though, where either on the one hand, it's a slight skew on whether it's a copy or whether it is about learning from different sources, because I think design is an iterative process. There is a substantial body of prior art. Seldom is anything utterly original, and actually often utter originality is not very commercially successful. So, it's a complex area. If we can maybe move to the slides, and I'll show some examples, John, that will try and perhaps put things into context. So in this first example, we are working together with a branding agency for Cepsa, who are the second largest petrol station or petrol provider in Spain. And we created together with Saffron this flagship station for them. This version is just outside Madrid, so it's the first installed. And in many ways, you know, we were learning from other sources. It was the first occasion where ETFE bladders had been used to form part of the roof. And obviously there is IP around those bladders themselves owned by the manufacturers. But also, you know, there's a design registration opportunity in terms of creating a unique design, which is both distinctive looking, it attracts people to it, it's a halo for the brand, they own the colour red as part of their brand. And it's a powerful way of combining, to some degree, improved environmental friendliness because the overall canopy is lighter, self-cleaning, uses less power, and is less heavy because of the approach to construction. So to some degree, in that case, you're learning from sources, but you could say, you know, there's an element of copying because you've learnt from slightly adjacent sectors in architecture and then brought this technology into that sector. If you move on to the next slide though, John, you know, in this case, our ambition as designers was to really try and change the customer experience. And I think the results of this project have been principally about creating a halo around the brand, some improvements to customer experience from the canopy and low-level lighting, but fundamentally the thing that people touch and engage with and drive the quality of the experience they get is the interface with the pumps. And you know, we were unable to make the changes that we want to make happen in the timescale of the project, and the thinking behind the idea has now disappeared into the pile of good ideas on the desk that probably, you know, will never see reality. The principal reason for that being, of course, you know, re-type approval of a new petrol pump is a substantial investment for a client, but changing, even simply changing the orientation of the pump and separating the controls from the pump and positioning somebody in the right place and using a screen in a way where you can see the person inside the shop that you're paying and they can see you, means that you can dispense fuel more quickly, things are in the right position, it improves the customer experience and it delivers, you know, better satisfaction. I would love for this kind of idea to be in the public domain, then others can learn from it and try and encourage the ability for change to happen that would not normally happen unless you become conscious of the value that you can bring through adopting a different approach. So in this case, I think there's a very definite argument for more open sourcing of these ideas and trying to ensure that greater change, greater innovation, greater transformation actually is delivered.
So sometimes it might be said that, that, you know, especially if one company decides it's not going to use something, then if there's a greater freedom to be, for that to inspire others. I think there is obviously a distinction between inspiration and copying, isn't there?
Yeah, there is. And I think that you can apply the same thing to patents. You know, obviously we trawl through patents, particularly if we're working in the aircraft industry looking for new formats or new concepts. It is slightly frustrating that so many of them are never actually utilized and deployed. And therefore, what you get is a smaller and smaller space for innovation in a way. And it becomes more and more difficult to actually deliver a bigger breakthrough or a bigger level of change, unless, of course, you move towards license agreements or something with the inventors. But often the inventor has lost interest and no longer has the commercial ability to take advantage of that. So it can make it more challenging. I'm not sure how you solve those problems, but I think they're interesting problems for us to all reflect upon. So if you can move on to the last example, I'm also conscious of time, need to give time for Sam to speak. So this is an example of work we've completed recently, working together with a startup who developed a concept for an advanced form of baby monitor. So the monitor actually clips onto the baby's baby grow, and it's tracking their breathing rate, their skin temperature, and their movement, and then providing information to a parent via alerts on a wristband or alerts on an app. And it's gathering data about the baby's well-being. You can also log feeding times and you can log nappy change times, so you can build up a complete picture of your baby's progress and their development. And we're also, with that same client, transiting this concept into the elder care sector, because essentially the data that you're gathering can be utilized in equally clever ways to the benefit of in the elder care market. Our client, the startup, sensibly have patented a concept around the way these devices communicate. So they had thought early on about the application of this concept, not just relating to baby care, but also to potentially to other sectors. And we registered the designs for them, or supported them in registering the designs, so that the kind of look and feel and format of the design is protected in appropriate markets. But of course, the value that they're going to create over time, and I think there'll be an increasing number of examples of this nature, is actually the data that's gathered, and then how that data is then turned, into machine learning that brings an improvement or a benefit. And there is clearly a big question around how open source that understanding is, because if this is a healthcare product that could benefit society at large, there is a huge opportunity to improve well-being within the country, and also potentially, and take huge pressure off the NHS. So if you can track your elderly relative remotely, understand how much they're moving around, what their activity levels are like, what their skin temperature is like, there's a massive amount of data that you can gather, and a massive amount of reassurance you can get as a carer. And this technology is available now. It's going to become available much more quickly, but open sourcing of that, and more transparency around the learnings that are being gathered could really help society in general. So in that case, I would say, yeah, there are cases where copying, following, or having available material that lets you accelerate your learning and development is clearly of huge importance. Okay, I think that's my bit. Can I hand over to Sam?
Yeah, Sam, why don't we look at this from a slightly different angle now, literally maybe, because looking at architecture.
Thanks. I guess in the conversations we've had leading up to this event, we've talked about different kinds of design, different sectors, different reasons why you might be hired as a designer, different ways in which the projects you work on kind of exist in the world. And in some ways, architecture is very different, because it's not really about brand, it's not really about product in the same way as John and Martin have been talking. And in fact, the ownership that you have in terms of intellectual property is kind of different. It's in the drawings that you produce, not the thing that you make. And maybe that's partly why I would say I think copying is a very important and useful way of culture developing. And of course, it's intrinsically part of all creative practice, but I would say perhaps especially architecture, which often tries to make something which is civic, which often uses things which are very recognizable. And I've got some examples here. So these are examples where copying is kind of both weird and produces something very different. So on the left of the screen is St. Peter's in the Vatican, produced by a series of different architects, including Michelangelo. So it's a very top-notch piece of work. And on the right is a church, actually the biggest church in the world in the Ivory Coast, Our Lady of Peace of Yamoussoukro, which was built by the president after independence, and is almost a replica of St. Peter's. And it was built as a gift, in a sense, to the Catholic Church. And it was about kind of the Ivory Coast and the president establishing certain kinds of links with the Vatican, which was to do really with power. So the copy here has a very specific reason why they were using St. Peter's. So if we have the next one. This is maybe a more familiar story, where we produce replicas and copies of buildings for specific reasons in terms of heritage. So on the left, the Frauenkirche in Dresden, which collapsed during the Allied bombing raids in the Second World War. And on the right is its reconstruction. Now, in order to produce this copy, there had to be incredible scholarship and almost kind of forensic archaeology in order to reproduce what had already existed. And in doing so, it kind of salvaged the reputation of the architect who had built the original building, where people had said, oh, he wasn't very good structurally. But actually, the process of conservation and reconstruction produced something which kind of vindicated the original architect's professionalism. One more, John. And here's one, this is Palladio's Villa Rotonda on the left in Vicenza. And on the right, in Nablus, in the Palestinian territory, is a replica built by the self-styled richest Palestinian. Now, Palladio, of course, was an architect who was very interested in copying, because he copied lots of Roman and Greek elements, like everybody did in the Renaissance. So the elements, you can recognize where they come from, but he puts them together in a way which is entirely new. This replica, I think it's interesting because it's it's the Villa Rotunda is a kind of a high point of Western culture, and here it is built in very contested territory. So if bulldozers were sent to demolish the Villa Rotunda, it might be a very different kind of news story. So there's a motivation as to why something might be copied, which I think is interesting. The copy might not be the same as the original, even though it might look the same. A couple more, John, next one. As a designer, I'm really interested in making copies and replicas. This was a very small project for the Architecture Foundation up at Highgate Cemetery. And on the left is a mausoleum designed by the Austrian modernist Adolf Loos, which was never built, but it was a very famous project in architecture. And on the right is our kind of one-to-one model of it, constructed very, very cheaply as a sort of ghost of this very heavy structure. So it's about the kind of transformation. So on the one hand, you recognize what it is, and on the other hand, it becomes something else entirely. Similar to the next one, John, which is a one-to-one replica of a standing stone from Avebury, sited on Midsummer Boulevard in Milton Keynes. And we produced this by going down to Avebury, 3D scanning, CNCing, polystyrene, coating it. And when we coated it with a kind of, the kind of paint you get on a custom car that changes color when you look at it from different directions. So it's a sort of remake of the Neolithic, but in a kind of, in a Milton Keynesy type way. So again, it relies on it being both recognizable and different at the same time. And maybe one more, John. So this was a project we did for LDF exactly this time last year, which was a project, it was about the uses of plastics and ways of rethinking our relationship to plastic and to objects. There was a big installation hung in the entrance of the V&A with an animated film in the top of this mirrored cube, which was a kind of a take on a design, a pattern design by Charles and Ray Eames, which was called Sea Things, which was a very beautiful drawing of sea creatures. And our version of Sea Things started with sea creatures, but became more and more like bits of plastic rubbish, which are floating in those giant gyres in the Pacific Ocean. And that was one part of it. On the right-hand side, we remade objects from the V&A's collection. So again, we 3D scanned them, but we made them using kind of plastic alternative material. So this is on the right-hand side, it's a Neolithic beaker made with a plastic derived from shrimp shells on a plinth, which we copied the profile of, partly from a famous set of stools by the Eames, but then also the profile of plastic bottles, like a Coke bottle, Dr. Pepper bottle, or these kinds of things which might well end up in the ocean. So we were, in a sense, riffing on these references and using them in a kind of creative way. It absolutely relies on copying, but we're not, I think, in any sense trying to pass off. What I like about the idea of using copying as a fundamental part of creativity is that it connects you to the world which already exists. And for me, that seems to be an important part of a designer's role in society.
I mean, I suppose part of obviously where that comes back into sort of product design is that, trends are a known thing. I mean, most people are wanting to follow a trend or lead one, but they're expecting others to follow a trend. That's what happens. And so the perennial question for brand owners, designers, and of course, we lawyers is where is that line? Where are you, especially if somebody creates the first product in a category, you can't expect necessarily, unless it's patented, a monopoly on that entire product category. So you have to expect that other people, if you're successful, will copy you and I mean that loosely, in some way or another. And most of our clients certainly expect that. I mean, that's fair enough. That's fair competition. That's part of living in a capitalist society. But there's a line over which people expect you not to cross, and everybody's line is different, and that makes it very difficult to have these sort of white line rules. And as you say, in something like architecture, it might be that actually copying is I'm not going to say encouraged at all, but sometimes you might be quite honoured if somebody replicates a feature and it becomes a standard feature in other buildings, as long as the rest of the building perhaps is different. Or and sometimes if you're going back into history, then you might want to replicate something for posterity or for art or things like that. But of course, that isn't taking away people's livelihoods in a way that perhaps copying one of John's products is, because John's products are innovative and he wants to keep employing his employees and so on. And if he's copied too much so that it undermines his business, it's going to have a negative effect on those people who he pays to be creative.
I'm just looking at one of the questions, which was with the architectural replicas, do you have to pay anything to the original artist? Well, that's also to do with the controls of ownership of IP, I guess, which for different types of creativity have different lengths of time, but which also have a different motivation. The origins of patents, or at least the modern patent in the Industrial Revolution, was to stimulate investment in progress, I suppose, by granting monopolies. So, which is a very different thing to if you're Prince Charles and you want to copy a building from the 18th century. There's no way you could possibly pay a royalty to Robert Adam or whoever it is that you were ripping off. But you may be doing the same thing, but it's maybe to do with the kind of market context.
Yeah, I mean, the principle of most, sorry, John, 2 seconds. The principle of most intellectual property protection is that you get a finite period of time in which you get some form of right or monopoly in order to repay the investment that you have spent on your design, invention, whatever it is. And obviously the government or parliament of the day has chosen how long those periods should be, sometimes in conjunction with international treaties. And for example, a patent is protected for 20 years, but the deal is that if you get that patent monopoly for 20 years, after that, it's fair game. And that's how society moves forward. John, what were you going to say?
No, I'm just going to say, I think it's the motivation, isn't it? If you're taking an existing design and seeking to progress that design and to develop it, that is very different from the other type of imitation, which is to try and create a cheaper alternative that looks the same, feels the same, and is delivered at half the price, which would typically kill a brand if it's better, or reinforce a brand if it's a poor replica. And you see that obviously with a lot of the discount supermarkets creating their own versions of branded product.
Yeah, no, exactly. I do have a specific question here for Martin. I'm conscious that we're running out of time, so there's a couple of questions I'd like to just deal with. One question, Martin, which is very specific, is to do with, and it's one for the design consultants who are attending. If you are a design studio designing for other people, you mentioned at the beginning that increasingly you're being expected to give assurances that your design is original and so on. Now, this question is quite detailed, but just to gloss it, I mean, who would you say is normally responsible for ensuring against the risk of the unknown in terms of design? Because one of the things that, just to bring this into a broader discussion, one of the things about design is that you can't always know necessarily whether what you're doing has been done before. You can obviously do searches, but there is always a chance that you or your employee or somebody you're working with hasn't necessarily realized, or somebody you're working with has realized but doesn't tell you, that they have taken some form of inspiration from elsewhere. So there's always a risk that however original you think you're being, you are either deliberately or subconsciously emulating somebody else. And there are insurances that you can take out to deal with those sorts of risks. So what's your thoughts on that?
The difficulty with this sector is we probably need another hour just to go through the sheer complexity of it. I mean, we have professional indemnity insurance, and the premiums are growing substantially, particularly for those that involve patent infringement. So we always try and exclude patent infringement from any contract if we possibly can. And we look to mitigate risk wherever we can. We also, our professional indemnity insurance also covers us for a degree of any legal fees that may be required should we be pursued. I think this is an issue of increasing importance to designers. I think there's a tremendous lack of understanding of the exposure that designers face when they just sign a contract that says they will indemnify a client against any potential losses. And increasingly, legal departments within large corporations are working very hard to persuade people not to do that. So we work very hard to try and change those clauses by stating that we will, we are agreeing that we are not going to copy somebody. If we have inadvertently, we will then support them in making a change to those things where we can. And we have to push back very hard. That can be really challenging because they're often using excuses like, well, my legal department won't change. We have spent recently 2 years negotiating a contract with a client purely to get those clauses modified. And I think the key point I'm always trying to get across is that we are helping you create the value that you are going to commercialize and take advantage of. So why on earth should we be liable for what essentially is the benefit, the potential risk of infringement that may lead to, if you're the ones that are fundamentally.
Oh, I think we've lost Martin there. I have certainly. Martin, you've paused. Hopefully you'll come back in a second. We've actually, we've reached the end of the time that we
and of course.
Martin, we lost you for a moment. We lost you.
Sorry. Yeah, my internet is gone. I'm upstairs, not downstairs. But anyway, yeah. Where did I get to? And I'll be quick. Yeah.
It was just the last couple of minutes. So if you just want to recap the last point.
Okay, so I think we're very cautious about contracts of this nature. We spend time trying to negotiate the contracts to ensure that everybody is clear about what the responsibilities are, and we work very hard to persuade our clients it's actually in their interest to make sure that they're adequately protected. In some ways, they're relying on our business to give them protection for what should be a substantial component of the protection that they should have naturally within their business anyway. So, it's often not very meaningful for that client in reality. The difficulty is getting to speak to the person that understands the issues, and getting them to agree to that.
Yeah, thank you. I was just saying that we've run to the end of our time that we had said, but the discussion, we've still got a couple more questions, and I'm keen to cover them if we can. So if you're to the attendees, if you're able to stay, you'd be very welcome to, and we'll probably wrap this up within 5 minutes or so. One particular question that I would like to ask is to do with enforcement. It goes back, John, to the question we were asking at the very beginning about the combination of how small businesses in particular might go on the attack. And the question is, would you ever use purely social media to deal with an issue? I was going to just provide my perspective on that before perhaps asking you to say if you've got any comments on that. And that is, we've seen a couple of examples recently where social media has been used in combination with a legal approach. I do think that if you've got the legal rights to rely on, it gives you more options in terms of how you enforce it. Effectively, you've got the stick, which you may or may not choose to use. So I would encourage all designers and brand owners to get at least some form of protection, either through registered designs, which can be very cheap, or through trademarks or whatever it is. But we've seen some very effective uses of social media, perhaps as part of an enforcement strategy. A well-known and well-publicized recent example was where Hotel Chocolat had a slab of chocolate that it alleged had been copied by Waitrose. Now, there was a lot going on with that, but the cult following that was Hotel Chocolat took to the airwaves, if you can call it that, on social media, and took offence that its beloved Waitrose brand had done this. And although I understand, and we were obviously not involved, there were legal letters flying around in the background. What really won the day, perhaps the combination, but what really won the day was the sort of social media reaction that took place as a result, and the result was that that Waitrose pulled the product. Another example, which is perhaps a well-known example that a colleague reminded me about last night. I don't know if my fellow panelists have heard of Dapper Dan. Dapper Dan was an underground guy in the US who decided that he'd make an awful lot of money by ripping off all the major luxury brands, making knockoff versions of Louis Vuitton handbags and so on. And he did this undercover for about sort of 20 years and was very, very successful. But he did it using very original designs. All his designs were incredibly original. He just put their logos on it, which of course was highly illegal. And if only they knew where he was, they might have taken action against him. The irony of that debate, and the reason I bring it up now in answer to this question about social media, is the way that Dapper Dan story ended was that Gucci decided to copy him. They developed a sort of street design that was literally his copy of their Gucci product from 20, 30 years earlier. Now, in the US, there was absolutely nothing that Dapper Dan could do about this. Dapper Dan's not his real name, by the way, although it should be. There was nothing he could do about it because the design was so old by then. I don't know in the US whether necessarily it had any protection at all. So Gucci could have got away with it in a way that the other way around was not okay. Now, what happened in real life was that social media was so outraged at his being copied by Gucci, that Gucci did quite a clever thing. It decided in response, and social media alone allowed this response to happen. Gucci actually hired Dapper Dan, and he is now a consultant working, designing for Gucci. And so I suppose his answer would be that copying has been very good news because he made a lot of money out of it when he was doing it illegally, and now he's on Gucci's payroll. John, do you have anything you want to say about using social media to deal with issues?
Well, I mean, there are other examples. Obviously, there's the Aldi example and Brewdog and their anti-establishment IPA. There's examples of Aldi and Fever-Tree, which I was alluding to earlier. I think each of which used social media in a slightly different way. You know, the Fever-Tree example was very much around the taste. And it enabled Fever-Tree to talk about the smaller bubbles and the differences between the two products and so forth. But these are big companies with, you know, who have deep pockets and were able to fight through social media on an even playing field. I think the danger with a smaller company taking on a larger imitator is that you can so often get drowned out, and you have to be incredibly imaginative to be able to actually navigate through without having a whole load of legal letters flying through your letterbox about libelous claims and so forth, and citing prior art and all the rest of it. So it's a lovely idea, and if you can create that. You establish that truth that your product was before the imitator, and that you were the innovator, not the larger imitator. And you're brave. That's great.
Yeah, I mean, I mean, my view on this would be that it has to be part of the strategy. You've got to have the rights to rely on at all, and if you don't have the rights to rely on, then you should expect to be copied. It's worth bearing in mind, and as I say, there are other events where we'll be talking about this more specifically, that you have quite a few rights automatically by designing in the UK, by designing in Europe to some extent. You have some protection automatically whether you do anything about it or not, but the most important thing there is that you can prove your rights, and it's worth spending time either with a lawyer or on your own working out exactly what your rights are and documenting them at the time rather than hoping to cobble it together later when you're copied. And the other thing is that the legal approach is not the only approach. My bosses here will hate me saying it's got to be part of the picture. If you get, I'd like to think most lawyers worth their salt these days will give you discussion of a whole strategy around using the legal side of things as well as a commercial approach. We've had many clients who have taken an infringer and actually turned them into a customer, and all sorts of other commercial outcomes can sometimes happen as a result of being copied. So I suppose to wrap this up, there are times when being copied, it's not what anybody would normally choose, but it is something where you know, it can be turned into a positive, even if it is principally a negative experience. And the key is to think about how, when this happens, and it is a when rather than if you're successful, you must expect that people are going to want to emulate your success by cutting a corner or three. And the key is to make sure that you're ready for that and that you can make the most of any of those situations without it being an entirely negative experience. And that is through a combination of planning your legal reaction through having some rights up your sleeve, planning how you would deal with it on a PR basis, and using other methods as well to make sure that when you get to that position, you can make the best of it that you can. I would just like to wrap this up now by thanking, I've got a little slide to bring up, but just for further information, we've mentioned the other slide, the other webinars a few times, so I thought I'd throw that slide up, which gives you the dates of the future seminars. I'd like to thank my panelists for joining us today. It's very generous of you all to give your time, to give your different and not always entirely agreeing views on this interesting topic. And I hope that we've had a lot of people join us, so thank you all to all of you for joining us when I appreciate time is tight in this pandemic with a lot of demands on your time. So thank you very much to all of you for joining, and yeah, hopefully you'll join us again next year, and fingers crossed it can be in person. So that we are allowed to give you a glass of wine to say thank you for coming. So thank you all to all my fellow panelists and to you for listening, and have a good day.
Thank you, John.
Thank you very much.